say free speech or reproductive rights or anything like that. We really are focused more on the mechanisms of government than anything. And that includes, of course, voting rights. In addition to myself, my title at Law Forward is litigation director. My Stafford partner, Jeff Mandel, is the founder, president, and lead counsel of Law Forward. And then Mel Barnes is our first permanent staff counsel hire. So Mel is a full-time employee, a full-time lawyer for Law Forward. Mel does a tremendous amount of work, and I have to give Mel a shout out as well, because she had a significant hand in helping me to put together this particular slide deck, this PowerPoint. So thanks to Mel. So let's talk a little bit. I'm going to get into partisan gerrymandering in particular in just a minute, but I want to start out by zooming out a little bit more and talking a little bit more about voter suppression generally, because viewed in a certain way, partisan gerrymandering really is a form of voter suppression. We've lived with a lot of these things in Wisconsin over the past decade, and we're seeing them spread out across the country now, especially in these 450 something and counting bills that have been proposed in state legislatures across the country, where state legislatures are looking to cut back, restrict, or out and out suppress the right to vote. These are just a number of ways that that's happened in Wisconsin, and it's happening in other states as well. There are limits that are put on voter registration, and that can include not only things like, as I mentioned in the last bullet point up here, restrictions on ways that people can register to vote, or timing or things like that, but also physical locations. So when the ability to vote is restricted or changed because a voter registration site, physical site, is made inaccessible. It's moved off of a campus, it's moved off of a public transit line, or registration is only available to people through the internet. And we know what we have called what we call the digital divide, which is an extreme imbalance in the opportunity that people have to be able to access the internet in a way that they could register online. For many of us, it's super easy to do. We just jump online and we can do it. But that's because we've got access to the internet. We've got computers or devices that allow us to be able to do that quickly. So we have to think broadly in terms of opportunity to register to vote. In addition, there are requirements like the voter ID requirement, which is Wisconsin's has been identified as one of the most stringent in the country. And when we think about voter ID requirements, why are they voter suppression, or why can they take the form of voter suppression, given that even champions of voting rights like Stacey Abrams have said having some kind of ID requirements is okay. But the question is, how stringent are they, and how much of an opportunity do they really provide for people who are unable to either get or unable to afford to get the kind of requirement identification that's required? What impact does that have on the vote? I mean, it really does impact people's constitutional right to vote. Other kinds of voter suppression that we've seen in Wisconsin and elsewhere around the country are this idea of voter purges, or the massive removal or suspension of people's registration to vote. We saw that happen in Wisconsin in the fall of 2019. It was a case called Zignego versus the Wisconsin Elections Commission. And this is where the Wisconsin Institute for Law and Liberty represented 3 individual voters who sued, and they asked a state circuit court judge to require the Elections Commission to deactivate the registrations of, at the time, approximately 234,000 registered Wisconsin voters. That case was finally decided by our state Supreme Court just last month, and I represented the League of Women Voters of Wisconsin in that case, and we did actually end up winning that case. The Supreme Court held that the statute that the plaintiffs relied on did not actually require the Elections Commission to deactivate those registrations. So that was a victory. Another way that we see, another form we see voter suppression taking is in the area of felon disenfranchisement. And then I've also added prison gerrymandering here. Felon disenfranchisement simply means that there are certain times that people who have been incarcerated can vote. When they are off paper, they're able to vote. A lot of people don't know that, there can also be forms, and I'm not an expert in this by any means, and many of you might be more expert in it or knowledgeable about it than I am, but there are efforts that can be made to try to restrict their ability to vote, even after they should be entitled to vote. Prison gerrymandering is simply a technique where the location of people who are incarcerated, their physical location, for the purpose of the census and for the purpose of drawing districts, they're counted as being the district in which the prison is located, the facility is located, rather than where they are, where their residence is. And as we know in Wisconsin, we have I believe it's the highest rate of Black men between the ages of 18 and I think 35 or something like that, who are incarcerated as a percentage of the population of any state in the country. And so this really has a disproportionate impact on the African-American population in Wisconsin. So another form of vote suppression. And then, as we've seen most recently in some of the bills that have been proposed in the Wisconsin state legislature, restrictions on absentee voting, whether it's in person or voting by mail. Wisconsin has had for decades. We've had among the most liberal, meaning among the most permissive laws in the country in how we allow people to vote absentee, whether it's in person or by mail. That served us very well, apparently until the most recent election last fall. And now in relation to that, in the wake of that election, the legislature feels the need to cut back tremendously on the ability of voters to vote absentee, either in person or by mail. So we have to look at all of these things, all of these different techniques that don't exist individually or in a vacuum. They all work together collectively in the aggregate to suppress the vote, and especially as it applies to certain members of our community. So that's broadly speaking about some forms of vote suppression. Now let's take a look at partisan gerrymandering in particular. And partisan gerrymandering, to really set the stage for it and give it some context, I want to start out by talking about redistricting and what it is. And I'll just say that before I started working on redistricting litigation in 2010, I really didn't know what redistricting was or what it did. I simply didn't have any idea. And so it's understandable if people are confused about it, or they simply don't know about it, which might be even more likely. But we redistrict because every 10 years, the federal government takes a census. And those census data are released the year after the US Census Bureau takes that census. And in the 1960s, we had a series of cases decided by the United States Supreme Court. Those cases we referred to as the one person, one vote cases. And the court decided in the aggregate that that the US Constitution requires that districts be roughly equal in their population, and that's so that everybody has the same right to vote. There's not what we call a malapportionment among the different districts. So that is a principle that the court found in the United States Constitution. And so what is now required, and has been required since the 1960s, is that we have districts that are equal in population. Now we have different kinds of districts. So we have congressional districts, and we have 8 of those in the state of Wisconsin. We have state legislative districts. In Wisconsin, we have 99 state assembly districts, and there are 3 assembly districts nestled inside every state senate district. And then we have our local government districts. So for example, things like wards or aldermanic districts or congressional supervisory districts. These districts need to be equal in population. The standards differ just a little bit. In congressional districts, the United States Supreme Court has said those districts must be exactly equal in population. And so each of the 8 congressional districts in Wisconsin has to be down to the person, they need to be the same number. Courts tolerate a little bit broader, what we call population deviation among districts that are state legislative districts or our local government districts. And so there is a presumption that's developed through the years in the case law where a population deviation among districts, and by the way, that can be measured in some different ways. It can be measured roughly by comparing the most populous and the least populous districts, or by taking the overall population of the state, dividing it by the number of districts you're looking at to get to get at what's essentially an ideal population of a district or an average population, and then comparing the most and least populated districts to that ideal district. That's what we mean by population deviation. But however it's measured, the idea of population deviation in these state legislative districts and local government districts, the court has said there's a presumption that if it's up to 10%, it's presumptively okay. Doesn't mean it's necessarily constitutional, but there's a more severe burden on plaintiffs to be able to show some kind of an unconstitutional impact or intent that would arise from a population deviation below 10%. Above 10% population deviation, the court's going to give it a little bit more scrutiny. But that being said, population deviations, even in the range of 15, 17% or even more, have been found to be constitutional. So the point is, again, to zoom back in on redistricting, we redistrict every 10 years, and we do that in the year after the federal census is taken. So what's required when we draw maps in Wisconsin? And this is what happens as part of the process of redistricting. So I'm going to focus here on state legislative districts. So there are state constitutional requirements, and there are federal statutory requirements, and there are federal constitutional requirements. So first, the state constitutional requirements. There are actually very few. Legislative districts have to be contiguous, that's that second bullet there, and be as compact as practicable. And the boundaries of the districts need to keep political units intact. That means they basically need to follow the lines of wards, municipalities, or counties when it's possible to do it. Those are the state constitutional requirements, only 3. Now, there are other federal constitutional requirements, such as the population equality that I mentioned before, that arises out of the federal constitution. And there are also other federal constitutional requirements, for example, the Equal Protection Clause itself, which mostly manifests itself in these kinds of challenges in the form of a racial gerrymander claim. So, for example, if a plaintiff can show in litigation that a particular district or a set of districts is racially gerrymandered in violation of the Equal Protection Clause of the federal Constitution, a map can be struck down for those purposes too. In addition to those state and federal constitutional requirements, there is also federal statutory requirement, in particular the Voting Rights Act of 1965. In Section 2 is the primary tool under the Voting Rights Act that is used in redistricting situations to challenge a plan. And what Section 2 requires is that when we're drawing districts, we have to look for opportunities. The people who are drawing the maps have to look for opportunities to draw majority-minority districts. In other words, they have to look for opportunities to be able to draw districts that provide minorities, as they're defined under federal statute, with opportunities to select, or I should say, to elect candidates of their choosing. In other words, you need to draw districts in a way that they have a sufficiently substantial population of minority voters so that they can elect a candidate of their choosing. It might be a minority candidate, it might not be a minority candidate, but it needs to be a choosing of that particular population. And in fact, Section 2 of the Voting Rights Act is a tool that we used in the 2011 litigation, where I was one of the co-lead trial lawyers, and we proved that Act 43, which was the state legislative districts adopted in 2011, they violated Section 2 of the Voting Rights Act because 2 Latino districts in Milwaukee were drawn in a way that didn't give that sufficient voting power to Latino voters in those 2 districts. So those are the legal requirements. In addition to legal requirements, there are what we call traditional redistricting criteria. At least in Wisconsin, we call them that. There are other states where some of these criteria are part of the legal landscape. They're actually legal requirements. The most important of these is probably communities of interest. The idea that we are going to try to keep together in the same district people who have common concerns, and we want them to be kept together because they should be represented by a single representative, whether that's the legislature, an aldermanic district, a county supervisory district, whatever it might be. And in fact, to give you an example of this, one of the reasons that the federal court in 2011, in the case I just mentioned, the Baldus versus members of the Government Accountability Board case, one of the reasons that the federal court decided Section 2 had been violated in these two majority Latino districts in Milwaukee is that the legislature had drawn a legislative district boundary that was right down the center of one of the main thoroughfares at the heart of the Latino community in Milwaukee, and really bisected a community that should have been a cohesive whole. And so that's how communities of interest can come into play in Wisconsin. Again, it's not a strict legal requirement, but it is something that courts will consider. And in fact, communities of interest is one of the primary criteria that the People's Maps Commission that Governor Evers appointed a little over a year ago, that they're looking at. They're really focusing on these communities of interest. So now let's get back to partisan gerrymandering and talk about that a little bit. What is partisan gerrymandering? You've probably heard the term quite a bit. And you might wonder, well, where does the gerrymandering part of it come from? It's actually an amalgamation of two words, or actually a word and a name. The first is the name, and it's actually Gary. It's pronounced the hard G. So occasionally people who want to show that they really know what they're talking about will say gerrymandering instead of gerrymandering. And from a technical standpoint, they're right. But not that many people say it, so I don't either. I just go with soft G, Jerry. But Jerry comes from Elbridge Gerry, who was the governor of Massachusetts in 1811 when there were new districts that were drawn in Massachusetts. And one of those districts, the Boston Gazette commented, looked like a salamander. And so the name was born. They smushed together his name, Jerry, along with salamander, and we get gerrymander. That's where the name comes from. But what is partisan gerrymandering? As you can see on the screen, it's really the deliberate drawing of district lines to give a systematic advantage to one political party over another. There are other kinds of gerrymandering. I mentioned racial gerrymandering before. That's a different kind of gerrymandering. And partisan gerrymandering is specifically for the purpose of partisan gain, to advantage one political party and disadvantage another political party. So how do you gerrymander? How do you actually go about the process of it? And I'm going to show you how that's done. It's done through two different techniques called packing and cracking. And I want to give us put in front of you a hypothetical legislature here, or governing body that has basically 50 precincts or 50 units to it. And let's assume that 60% of the voters who are located in those districts, they prefer the blue party, and 40% prefer the teal party. If we were under a form of government where you had perfect proportionality between the voters and the party that they vote for, and the representatives in the governing body, such as a legislature, then obviously we would expect if 60% of the voters vote for the blue party and 40% vote for the teal party, that the blue party would have the majority in the legislature. Now, we don't have that form of government here. We don't have direct proportional representation like they have in some European parliaments, for example, where if a party gets 60% of the vote, they get 60 of the seats in whatever the legislative body might be. We don't have that here. And because we don't have that here, it does give an opportunity for districts to be cracked and packed, and for a party that receives a vote of 40% of the voters to actually have a majority in the representative body. How does it actually work? Well, let's work, and I've given an example here at the bottom, where if we divide that legislative body and the voters up into 5 different districts, you can see how the teal party could potentially win 3 of those 5 districts and the blue party only 2. How does it actually work? Well, first of all, it works in part through a technique called packing. So the idea is, if I'm a member of the teal party and I'm controlling how these districts are drawn, I'm going to first of all pack all of the blue voters, or as many of the blue voters as I can, into just 2 districts. Because if there are 5 districts total and it takes 3 to get a majority, then I want to pack as many blue voters as I can into 2 districts. They're way overpopulated with far more blue voters than would be necessary for the blue candidates to win in those districts. So these are basically safe districts here, 4 and 5, as you see on your screen, for blue voters. I'm gonna pack the blue voters in there. And then again, if I'm the teal party, I want to crack the blue voters in the 3 districts that I want my party, the teal party, to win. And what that means is I'm going to draw those district lines so they have just enough teal voters in them to win those districts, maybe 52, 53, 54% teal voters, something like that. And remember, I've packed so many of the blue voters into those districts 4 and 5 that there are not going to be enough blue voters to be able to win districts 1, 2, and 3. So that's packing and cracking. How does it actually play out? Well, we've got a diagram here on the screen in front of you. This was a graphic that we submitted in our brief to the United States Supreme Court in the Whitford versus Gill partisan gerrymandering case in 2017. And it's an illustration how packing and cracking actually played out in Wisconsin in drawing the district lines that we have in front of us now, that we still are operating under. If you look over on the left side of your screen, under the part of the screen where it says composite or current map, that represents in the upper left-hand corner that those are legislative districts surrounding Milwaukee as they were drawn in 2002 by a federal court. So in 2002, instead of the legislature drawing the lines, a federal court drew the lines. And those lines you see there are the actual state legislative districts that the court drew in 2002. Now, what we've done here is we've taken the 2010 census data, and we've put this 2010 census data, we've combined that with the districts as they were drawn in 2002. And the purpose of that exercise was to show the United States Supreme Court that if the Wisconsin State Legislature in 2011 had not changed the lines at all, if they had simply kept the same legislative district lines in place that the federal court had drawn in 2002, then of those 8 state legislative districts in the Milwaukee area, 4 would have been won by the Republican Party, and 4 would have been won by the Democratic Party. These are state assembly seats. Okay, so it would have been even. The Democrats and the Republicans each would have had 4 state legislative seats in the assembly coming out of that area. But instead, now if you go over to the right side of the screen in the upper right corner, you'll see where it says composite final map. Those are the state legislative districts, the 8 of them, that the legislature actually adopted in 2011. And so as you can see, this is an extreme example of cracking. So as we probably all know, those collar counties around Milwaukee are heavily Republican and made up largely of white voters. And so what the legislature did was it took those districts that you see in the upper left-hand part of your screen, and they extended them over into those blue areas. So they pulled those blue voters, those Democratic voters, out of those districts that they had been in before. And by pulling them out, I mean, obviously not physically changing location, but now those people are their residences are in new districts. So they pulled them out of those majority Democratic districts, and they made them now a minority of voters in these heavily Republican districts. And as a result of cracking those districts, the Republicans gained a 2-seat, picked up 2 seats in the state assembly because they did that. So instead of 4-4, now it's 6-2 Republican advantage. And on the bottom half of your screen, we can see the same thing played out in the Racine and Kenosha areas. Largely the same thing happened. Lower left-hand corner, again, you see those 2002 state assembly district lines populated with the 2010 census data. There would have been, if they just had been kept intact, there would have been 2 Republican seats in that from those counties in the assembly. There would have been 4 Democratic seats in the assembly. And by cracking those districts, the heavily Democratic districts in the cities of Racine and Kenosha, this is the lower right-hand corner, Republicans picked up a seat in the assembly. So that's how packing and cracking practically played out, at least in a couple of the different areas in Wisconsin in 2011. So let me shift quickly and talk about the Whitford versus Gill case, the partisan gerrymandering case. For several decades before we filed that lawsuit in 2015, the United States Supreme Court had been struggling over whether to hold partisan gerrymandering to be unconstitutional. And it had never reached a decision about whether it should or whether it shouldn't. And that's because there were blocks of justices on the US Supreme Court, some of whom thought it should be unconstitutional and some who thought it shouldn't be. And in fact, there was an even split for several decades where there were four of what we tend to call the liberal justices on the United States Supreme Court who believed that partisan gerrymandering was unconstitutional. And there was a fairly consistent block of four conservative justices on the US Supreme Court who consistently took a position that legislative districting is a purely political action, and the courts should not have anything to do with it. They should just simply leave it to the political actors to do. That's 4-4. Well, we have 9 justices on the United States Supreme Court, and so there was always a tie there at least. But what about that other 9th justice? Well, that was Justice Anthony Kennedy, and for a couple of decades, Justice Kennedy said, I think partisan gerrymandering is bad. I think it's probably unconstitutional. But Kennedy's problem was that he couldn't find a workable standard to decide when an action that was fundamentally political, the drawing of districting lines, when it crossed the line and now it became so extreme that it actually violated the constitutional rights of voters in the states. So Justice Kennedy spent a couple of decades looking for or asking litigants to give him a workable standard. How can you decide when a legislature has gone too far? It's basically exceeded its authority under the Constitution to answer this purely political question. What should the districts look like? And now it's gone so far that it's violated constitutional rights of people living in the state. And so we attempted in the Whitford versus Gill case to provide Justice Kennedy with that answer. We wanted to give him the standard that he needed to have to be able to find it unconstitutional. So how did we do that? Well, we proposed a 3-part standard, and what we proposed, and this was based on longstanding legal doctrine, we just simply took out of other contexts of constitutional challenges to state statutes. And we put it into the context of partisan gerrymandering. So we said, we as plaintiffs in the case should have to show that the legislature in districting had a partisan intent. They intended to advantage one political party over the other, in this case, the Republican Party in Wisconsin in 2011. Second of all, wasn't enough just to have an intent, but it had to have an unconstitutional effect. I'm going to talk about it a little bit more detail in just a minute, but basically, we proposed that the court use a metric called the efficiency gap, something you might have heard of, which is simply a calculation of wasted votes. And again, I'll explain that a little bit more in just a minute. Then we proposed a third prong of our 3-part standard. We proposed that if we as plaintiffs were able to show those first 2, intent and effect, that the burden should then shift to the state, and the state should have to show that it had some kind of a neutral justification for drawing the districts like it did. And we'll talk about that a little bit as well. So first of all, the first part of our proposed standard, partisan intent, we said we should have to show the legislature had an intent to advantage one political party over another. The way that we really did that, and this was the most powerful evidence that we submitted in the case in this point, we had gotten in the earlier lawsuit in 2011, the Baldus versus members of the Government Accountability Board case, we had obtained a court order, this is from the federal court in Milwaukee, that had ordered the legislature to turn over to us, it was actually the Republican caucus, to turn over to us the 3 computers that the Republican legislative aides and their consultant used to actually draw the legislative district lines that resulted in Act 43. And when they did that, we then had those for the purpose of the Whitford case. And in Whitford, we engaged a computer forensic consultant who was able to extract from those hard drives all of these proposed plans that those map drawers from the Republican caucuses that they actually created. So they didn't create just one proposed map, the final map. They actually created dozens and dozens and dozens and dozens. And so we showed the court a progression of those maps to show that there was an intent to advantage the Republican Party. How did we do that? Well, what I've shown on the screen here in front of you, again, these are the legislative district lines or the assembly district lines as they existed in the 2002 plan. So these are the lines that were drawn by the federal court in 2002. And again, we populated these with the census data from 2010. And these are projections, by the way, that came from those computers. So this was not something that we as the plaintiffs in the Whitford case were attempting to project. This is actually the work of those legislative aides and the consultant as they were going through this process. So what this shows is that if they had just kept the district lines intact from 2002, when they were drawing new maps in 2011, Republicans would have, by their own projection, Republicans would win in the 2012 election 50 of the 99 state assembly districts. They would have had a 1-seat majority in the assembly. But of course, as I said, they didn't draw just one proposed map. They drew many. Let's take a look at those. And we ran through these in order, essentially at the trial. So here's a map that was drawn by the consultant Joe Handrick. This is his map number 11. And as Joe Handrick's map shows, the map drawers projected that this map would result in the Republicans winning 53 seats in the state assembly. And when I'm talking about projections here, they had pretty sophisticated algorithms that they used, that they developed with the help of a political science professor at the University of Oklahoma named I'm going to have to ask now, where did I cut out, Bonnie?
Not really sure.
Did you see this slide?
I think that's where we were.
Okay,
before that.
all right. Okay, all right. So this was to show that we proved partisan intent. So let me move into the second prong then, and that's partisan effect. And so what we were trying to show, or what we proposed in terms of showing partisan effect, was we encouraged the court to look at it using this tool we had developed called the efficiency gap. This was developed by Nick Stephanopoulos, who was a law professor at University of Chicago at the time. He's now at Harvard, along with a political scientist, Eric McGee. That is a metric that attempts to measure what we call wasted votes. If you remember when I showed before the slides on packing and cracking, the packing slide, I showed that you're trying to pack more voters, more of your opponent's voters in there than are necessary to actually elect a candidate that they want from that district. Those are wasted votes. Any vote that's above the number that is necessary is a wasted vote. And in the same way with cracking, you're trying to waste as many of your opponent's votes as possible by cracking. So those are wasted votes. The general idea, though, behind the efficiency gap is one of partisan symmetry. And that is, I'll explain it a little bit more in just a minute, but the idea there is the goal is to have an equal opportunity for candidates from each political party to win. You basically want the debate to be about policy, and for people to be running, candidates to be running on policy, and voters to be choosing candidates based on policy, not just partisan affiliation. So that's partisan symmetry. So we said we should have that to prevail in this partisan effect, we should have to show both a large efficiency gap, which would show a partisan asymmetry, and we should have to show that was intended to endure over the course of an entire decade. And so the screen that I'm showing in front of you now, I recognize you can't read what any of those lines say, but let me just describe it for you. Running right down the middle of the screen from top to bottom, there's a solid black line. At the bottom, it says average efficiency gap, and it's got a 0.0. That would be a perfectly neutral plan from the standpoint of the efficiency gap. In other words, that's a plan that does not waste votes of either side, or wastes votes equally, at least for Republicans and for Democrats. So there's no party advantage there as measured by the efficiency gap. That would be a neutral plan. Everything to the right of that solid line that you see represents a partisan gerrymander in favor of Democrats in a state legislative plan in the United States between 1972 and 2014. We had one of our expert witnesses look at every single state legislative districting plan in the US during that time period to rate their efficiency gap and then to plot it. So again, everything to the right of that solid line is a Democratic gerrymander. Yes, Democrats have done it quite a bit in the past. Everything to the left of that is a Republican gerrymander. And the reason that we showed this this particular diagram to the court, in the lower left-hand corner, you'll see a red circle and it says Wisconsin Act 43. So Act 43, that's the state legislative, the assembly districts from 2000 and Senate districts from 2011. It's the fourth most extreme partisan gerrymander between 1972 and 2014, as we measured it and presented it in the Whitford case. So that was one piece of evidence that we used to show a partisan impact. Partisan asymmetry, I mentioned just a minute ago. I'm going to go ahead and skip that slide here in the interest of time. But let me show you, give you a little bit more of an idea about partisan asymmetry and what it means. And this is a footnote on the screen in front of you. This is a footnote actually that came from the court opinion in 2016, holding that we prevailed on our claims. What the court did is it looked at, again, looking at just taking files from the computers that the map drawers used. These are the Republican aides and their consultant. And so they deliberately designed the overall state legislative districting plan so that, as you can see, there are 4 columns here, so that if Democrats on the left here received 47% of the vote, they would only win 33 seats in the assembly. Whereas if Republicans won 47% of the statewide vote, they win 50 seats in the assembly. Now, as you go on down, progress on down the sides, go down toward the bottom of the page on each of those 2 columns, you're going to see no matter whether Democrats win 47% of the vote or 54% of the vote, you know, they can't, or I should say 53% of the vote, they can't get a majority in the state assembly under the plan the way the Republicans deliberately drew it. On the other hand, Republicans are always going to have a majority, regardless, as long as they get 47% of the vote. So it takes Democrats 53% of the vote under this this plan to win 49 seats. So they don't even have a majority there. They've got to get greater than 53% just to get a majority in the assembly, whereas Republicans get a majority in the assembly if they only have 47% of the votes. That is a significant and extreme partisan asymmetry, and it was done deliberately. And it was done deliberately not to give a large advantage to the Republicans, but an enduring advantage. In other words, it was designed so that their gerrymander would last the entire decade. And in fact, that's exactly what happened. As you can see here, I've put on the screen in front of you the vote share and the seat share in the assembly from 4 different elections. These are the general elections from 2012 to 2018. No matter whether Democrats won 45% of the vote, as they did in 2016, or 53% of the vote, as they did in 2018, they are not going to get more than 40% of the seats in the assembly, period, versus Republicans. And Republicans, no matter whether they get a little bit less than 45% of the vote or they get 52% of the vote, they are always going to have at least 60% of the seats in the assembly. That was by design, and that alone is why we've had a significant Republican majority in the assembly for the past decade. It's not to say Republicans wouldn't have necessarily had a majority. They might have had a majority, but it would have been much, much smaller. So we proved partisan intent, we proved partisan effect. The third prong that we said then for our standard was that the burden should then shift to the state to show some kind of a neutral justification, some kind of an innocent reason, nonpartisan reason why they drew the map the way that they did. And the argument they go back to time and time again is something that we call political geography. And what they say is that, well, Democratic voters are just so concentrated in the cities and Republican voters are just spread out throughout the entire state. And so Democrats have basically gerrymandered themselves. That's the argument that they've made. Now, there is a kernel of truth to that. There is a small kernel of truth to that. And it is true that if you look at the political geography of the state of Wisconsin, and our expert testified to this in 2016, it would give Republicans a slight advantage to have a majority in the assembly. Our expert calculated about a 2.2% pro-Republican advantage just as part of the natural political geography, just from where voters tend to be located. But there was such an extreme pro-Republican advantage baked into this plan, a 12% advantage, that our argument was that you couldn't explain it all from political geography. And the diagram that you're looking at proves it. We engaged an expert, Joey Chen, a political science professor at University of Michigan, to run 200 computer simulations that would draw districting plans. In other words, to use all the criteria that should be used, the legal criteria, but not to use partisanship to draw districts. And so when he did that, he drew 200 districting plans, and then he evaluated the efficiency gap of each of them. Those are the red circles that you see. They're plotted out there. And you'll see that the pro-Republican advantage, which is expressed over on the left-hand side here, going out to about -6%, that shows how the plans would have skewed in terms of a pro-Republican advantage. A pro-Democratic advantage would have been to the right of that. It goes up to about 2.5%. And you see that there is that clump of red circles. That's what we would expect to see. So if you look where Act 43 is, it's an extreme outlier. If partisanship wasn't the driving criteria for what the Republican legislature did in 2011 in drawing state legislative districts, you would have expected to see the overall efficiency gap for Act 43 to fall someplace within that clump of red circles. It did not. So we were able to disprove their theory that political geography was the cause of this extreme gerrymander. So we went up to the United States. As I mentioned, we won at the district court level. After we tried the case, we went to the US Supreme Court in 2017. The court issued a ruling in June of 2018. And the court didn't say we won, the court didn't say we lost. The court basically said, well, you failed to prove at trial a technical requirement that you need to be able to show as part of a federal court case. And that is something that we call standing. You've got to show an actual injury under the federal constitution. In the interest of time, I won't get into it in depth, but basically they just said, we're going to send you back down to the trial court so that you can prove standing. The important part of that is they didn't say you lose. They didn't say, we are going to examine your partisan gerrymandering claim and we reject it. Instead, they just said, we're going to send you back down so that you can have another shot at proving standing and another opportunity to retry your case. Well, that got remanded to the district court for a new trial in the fall of 2018, and we got a new trial date in July of 2019. In the meantime, there was a case that the Supreme Court decided called Rucho versus Common Cause. And it was essentially a carbon copy of our lawsuit in Wisconsin, the Whitford case, but it was in North Carolina. And the Supreme Court, the US Supreme Court, decided that case in June of 2019. As Bonnie mentioned at the outset of this broadcast, what happened was that the US Supreme Court decided that you could not bring a partisan gerrymandering claim in a federal court. Those claims are non-justiciable political questions. So now you might say, well, what changed? Why in June of 2018 did the Supreme Court not pull the plug on you entirely? Why did they say, well, you can go back down and you can try to prove your claims again? Well, the composition of the court changed. In 2018, when they decided Whitford versus Gill, Justice Kennedy was still on the court. And you can see them in this photo. He's second from the left next to Chief Justice Roberts. He retired about, I think it was about a week or 2 weeks after they decided the Whitford decision. He was replaced by Justice Kavanaugh, who, as you can see in this photo in front of you, is over on the right of that picture. And Justice Kavanaugh sided with the other conservatives on the court and held partisan gerrymandering is not justiciable as a claim in a federal court. So with that, what legal avenues do remain to challenge partisan gerrymandering in Wisconsin? Well, we have some potentially under the state constitution. We have many of the same provisions in the state constitution, free speech, equal protection, freedom of assembly, that we have under the federal constitution. And those federal constitutional provisions provided the basis for us to win in the Whitford case and some other plaintiffs to win in federal courts in other cases. In addition, Wisconsin's got a clause, the Free Government Clause, Article 1, Section 22, which might, provide a basis to challenge partisan legislative districts as a partisan gerrymander, but that's untested. It's never been brought to a court before. In addition, there are other legal grounds to challenge new legislative districts. In state courts, we could bring claims challenging them under state and or federal law. Federal courts, we still have claims under the Voting Rights Act of 1965, and as I mentioned at the outset, racial gerrymandering claims. And there are always legislative options as well. The legislature could adopt a constitutional amendment. It would have to pass the legislature. Then there would have to be an election. Then there would have to be another. It would have to pass the legislature again, and then it would go to the people of the state to vote it in as a constitutional amendment. And then there still is HR 1 is pending. It's a federal statute that would, at least for congressional districting, would invalidate partisan gerrymanders. And just the last slide I'm going to show you here is what else we could require to put some fairness into our maps in Wisconsin. We could do things like establish a nonpartisan commission following the Iowa model. We could require a supermajority vote in the legislature for legislative districts to be adopted. That would prevent less than a supermajority from adopting a set of districts that favored one political party over another. We could also put into place some standards, some enforceable standards that would be part of the test for compliance with the law, such as could just outright ban partisan gerrymanders, or we could put competitiveness standards in for districts, or we could include communities of interest as a legal standard. So in the interest of time here, I think what I'm going to do is I am going to stop sharing my screen, and Bonnie, let me see here, there we go. And I'm going to open it up for questions there. There we go.
Great. Thank you, Doug. This was great. Incredibly informative and detailed and helpful. I want to ask if people can put their questions in the, actually, you know what, there aren't that many of us. I think if you want to unmute yourself, anybody who has a question, you should be able to unmute yourself and ask your question. And while people are formulating their questions, I have a question for you, Doug. There are a couple of bills currently before the legislature that have to do with gerrymandering, and I was wondering if you could catch us up on those.
Well, there is a bill that's been introduced in the Assembly, and that would essentially, Deb Andraka is one of the originators of that bill, and that bill would put into place a nonpartisan model, like in Iowa, that redistricting would be done through that model. There are so many bills right now that are pending, it's easy to get them confused. There is also, in addition to the state legislative districting bill, there are some bills that have been proposed for local redistricting. That's been in the news a little bit more lately. And so there's this timeline. I didn't show that slide before, just in the interest of time here. We have a little bit of a difficulty this year, a time crunch. Typically, the Census Bureau data that are used for the purpose of legislative redistricting are released by March 31st of the year after the census is taken. And our timeline in Wisconsin for doing all of our districting, new districting, state legislative districts, congressional districts, aldermanic districts, county supervisory districts, all of that is really based on the idea that we're going to have that data as of March 31st. We're not going to have the Census Bureau data this year until sometime in August. When the Biden administration came in, it said that the Census Bureau data was either not complete or is inaccurate. It needed to be verified and completed, and so we're not going to have that. We're not going to have that data until sometime in August or September. Part of the difficulty that creates is that our by statute, our municipalities and our counties have to create new wards and supervisory districts under a timeline that actually kicks off in July. They're not going to be able to do it. It's just impossible. There's also a practical difficulty because remember, we have elections in the spring for our local units of government. for a candidate to run in one of the spring elections in 2022, they're going to have to start to circulate nomination papers in December of 2021. And so that leaves only a matter of time from either August or September up until beginning of December for municipalities to create new wards, for counties to create new supervisory districts. And that can be a little bit of a complex process, can be a little bit of a back and forth. And so what the legislature did is it introduced a bill in the Assembly and the Senate that would freeze those districts in place so they wouldn't change until 2023. That at first, it facially appeared to have some appeal to it, but there were a number of municipalities and counties that didn't like it. In addition, there was some investigative reporting done by Melanie Conklin of the Wisconsin Examiner that found that those bills didn't actually originate from the Counties Association as they were said to have originated. It turns out they were actually either written by or had some involvement of one of the names of the people I put up before in those maps was Joe Handrick. Joe was a consultant. He was the consultant who assisted the legislative aides in drawing the gerrymanders in 2011. He still works in some capacity with Representative Voss's office. And as it turns out from Melanie Conklin's reporting, Joe Handrick had been one of the people behind the local redistricting bills. And so there's just been a lot of concern and suspicion about whether this local redistricting bills, whether these bills are an attempt to try to assist in a partisan gerrymander overall of the state legislative districts. So there's a lot that's going on right now on the local redistricting side. There's nothing that's actually happened legislatively on the state legislative redistricting side because this bill that's sponsored by Deb Androck and some others hasn't whether it actually sees a floor vote or not is really up in the air.
Thank you. Do we have other questions? Anybody want to unmute yourself and ask Doug a question?
I have a question, Doug. Let's say the Republican legislature proposes redistricting and Governor Evers vetoes it. Could you describe the likely process that would occur then?
Sure. Yeah, it's a good question, Eric. Thank you. I've gone on record here quite a bit this spring as saying that if the process that Eric describes, which is an impasse scenario, if that were one that were to occur, I actually think that would be a victory for the people of Wisconsin. And one of the reasons I say that is that I think our processes political processes have broken down so much over the past decade with the increasing partisanship that if we just kind of get back to normal and do things in a normal process, I think it would be a win. In other words, what should happen as part of the redistricting process is that once those data are released by the Census Bureau, the Republican caucuses in the Assembly and the Senate would get computers and software and data from the Legislative Technology Services Bureau, which is a nonpartisan bureau that provides all the technology support for the legislature. The LTSB would give computers and software and data to the Democratic caucuses as well in the Assembly and the Senate. The two caucuses, they would do their own things. They'd come up with their own maps, and then they would introduce proposed legislation on the floor of the Assembly and the Senate. They would robustly debate it. There would be hearings with a real opportunity for not only politicians, but for regular folks just like you and me to be able to go in and testify about what they thought about the plans. Nonprofit groups could go in, government groups could go in, individuals could go in, but there would be some kind of testimony. There would be that robust debate among legislators, and then they would take a vote. I don't think that there is any doubt how that vote would go given the makeup of the legislature these days. I think the Republicans would adopt state legislative districts that would probably give them an advantage. Then there is what we call a presentment clause, the Wisconsin Constitution. And that requires any proposed legislation to go from the legislature to the governor and be presented to the governor, so the governor could sign it, or the governor could veto it, or the governor could pocket veto it, just not sign it or veto it, and then it dies if it's not signed within 10 days. So that would be the normal process that we would see. That's an impasse situation. Then what would happen is there would be a court procedure, a court process. It could be in a federal court, it could be in a state court, but a court would hear that dispute. It would hear evidence from one side. Well, I shouldn't say just one side. It would hear evidence from probably a number of different groups. It would hear evidence put on probably by the legislature. It would hear evidence put on by nonprofit groups. It could hear evidence put on by the governor if the governor wanted to participate. But ultimately, the court would decide on what the state legislative districts would be. That would be a process that would be that would be a best case scenario. Let me give you a little contrast, Eric, to that sort of preferred scenario. There's been a great concern among many people, me included, that the legislature, instead of following that process, will attempt to create new state legislative districts through what's called a joint resolution of the Assembly and the Senate. In other words, they would try to do through this resolution what they're supposed to do by statute. And when I say supposed to do, I mean because there is a 1963 Wisconsin State Supreme Court opinion that says that legislative districting, that process, needs to be done through legislation, not through a joint resolution. Nonetheless, I think there is there's a concern that the legislature might try to be very aggressive. It might try to create new legislative districts through a joint resolution, and then say, you don't like it, fine, sue us. That would throw things into turmoil and would just create a lot of conflict where really that conflict doesn't need to be there.
Thank you. Do we have any other questions? Doug, what can we do right now as individuals to raise our voices?
Well, yeah, so I think that's a great question, Bonnie. We get that a lot. There are a number of different efforts that are going on to increase the participation of people in Wisconsin in this process. One thing you can do is you can go to our website, www.lawforward.org, and you can sign up to receive our emails so you can stay up to date on what's going on with redistricting. In addition, we have a publication that we thank you for posting that in the chat box. We also have a publication we've created called Redistricting 101, where we really explain the process as best we can in we think non-legalese and easily understood terms. And you can obtain a copy of that paper from our website as well, and feel free to share it with your friends. You can of course follow us on Twitter and Facebook for news on redistricting. In addition, hopefully folks have heard of the Fair Maps Coalition. And the Fair Maps Coalition is a very broad-based coalition. I don't know if WIVIC has participated in the Fair Maps Coalition or not. Bonnie, you can probably shake your head yes or no if they have. Yeah, so this is a very broad-based coalition. It consists of dozens of groups around the state that is very engaged in the process of redistricting. And so they've got a petition that they sign, or that they came out with to encourage the adoption of nonpartisan redistricting in Wisconsin. You can certainly sign that petition. You can follow them. In addition, I mentioned the governor's the People's Maps Commission that the governor appointed a year ago, that is in the process of took testimony in the 8 congressional districts, and it is now engaging in a process of attempting to draw maps. As part of that process, people can go online and they can actually draw their own local communities, their communities of interest that they want to see. And there is a particular program called Districtor that they use, and they're looking for people to give input on that, to actually say what they consider to be a community of interest in the place where they live. And so I don't unfortunately have the ability to post a link for you there, but this is the People's Maps Commission. I can always send a link, Bonnie, to you. Oh, well, there you go. You've got it up already. And would encourage everybody to do that, to go there and to look for that district or tool and the opportunity to draw your own district, to show what you think communities of interest in the area that you live, that they look like, that those look like.
Great, thank you so much. If everybody would look to the Wisconsin Interfaith Voter Engagement Campaign's weekly newsletter, going to come out on Monday. When we're going to have a couple of things, items in there about gerrymandering. We'll have a link to the recording from today, the League of Women Voters is doing a training, I think Tuesday, on how to draw your own map. So we'll have a link to for you to register for that training. And the Wisconsin Democracy Campaign just came out with some information on some bills before the legislature. So we'll have some information on that as well. So thank you, Doug, so much for being with us today. This has been really valuable. It will be up on Facebook. It will be up on YouTube. Please share this information, everybody, with your friends, your congregations, your networks. The more that people know about the process and what's happening, the more that we can raise our voices and let our legislators know that we want our maps to reflect who we are as voters. Thank you so much, and thank you all for being with us today. We will be in touch. Everybody have a wonderful weekend and a wonderful Juneteenth.
Thanks, everyone. Bye-bye.